Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. I apologize for the air conditioner roar this morning. It can't be helped. But please speak up so that we can all hear. We'll hear argument in three cases this morning. First is 19-1144, the City of San Antonio against Maspero from Bexar County and the Fourth Court of Appeals District. Then 2293, the City of San Antonio against Riojas from Bexar County and the Fourth Court of Appeals District. And finally, 2384, Henry Christensen Air Conditioning and Plumbing, a petition for writ of mandamus from Travis County and the Third Court of Appeals District. We've allotted 20 minutes for each side in each case, and we'll take a brief recess between the arguments. The arguments are being webcast live this morning and will be available in the court's archives later today. We're ready for argument in 19-1144.
May it please the court, Mr. Moore will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning. May it please the court. Police pursuit in a motor vehicle is not enough alone to trigger a waiver of governmental immunity. Instead, pursuit plus is required. And the plus is the reckless operation or use of a motor vehicle, and that the reckless operation or use of the vehicle actually caused the complained of injury. Here, there is no evidence of either requirement. There is no causal nexus between the operation or use of Officer Corey's police cruiser, and there is no evidence that Officer Corey was acting recklessly in the operation of her car at the time of the incident. And that's going to be critical. I'm going to ask the court to focus on the at the time of the incident portion of this accident. The Court of Appeals got both halves of the plus analysis wrong. First, it got the causal nexus requirement wrong when it misconstrued this court's opinion in Ryder and reached this erroneous conclusion, quote, "We cannot say that the driver of the Suburban would have driven the wrong way in traffic and hit the Masperos Volvo head-on, but for Officer Corey's decision to use her motor-driven vehicle to chase the Suburban without activating her siren." And second, it wrongly concluded that a fact issue exists with regard to whether Officer Corey acted recklessly at the time of the incident in the operation of her vehicle.
Excuse me, how can you say that it would not be foreseeable that this kind of thing would happen when the police officer had made the decision, or the police department, that they knew that these cars that were leaving this marijuana production area were probably going to be full of marijuana? And so their goal was to let them get a certain amount away from that facility, look for some kind of a incident. In this case, I think it was failure to put on a blinker to change lanes. And then how is it not foreseeable that number one was going to cause the driver to flee, and that once that happens, all kinds of chaos comes about?
It's two parts, Judge Lehrmann. First, the decision to pursue is a discretionary act for which they retain their immunity, and it doesn't waive immunity, even if it would be foreseeable that something happened from that. The decision-making part of it, Officer Corey retained her immunity, and the planning of it was an immune act. Otherwise, every police pursuit would give rise to a foreseeable act, because we know from this court's opinions in Chambers and Wadewitz that high-speed pursuit chases do pose a danger to the public. So that's that line of cases.
What about the fact that I think the record shows the policy was that the officer needed to get permission and did not?
Two parts. There's no explicit permission. Officer Scaramosi and Officer Ortiz both testified in their affidavit that she had implicit authority. So factually, I don't think that's technically correct. I think the other portion of it is there's no causal nexus between the pursuit in this case and the accident. And that's one thing that the Court of Appeals got wrong. The pursuit had virtually ended. All of the conduct that the Court of Appeals focused on, in its opinion, was the conduct that happened when he fled. The court knows that he initially pulled over, she initiated to stop, he appeared to stop, and then he took off. The record reflects that he drove up to 100 miles per hour and blew through 2 intersections, and Officer Corey did not. She didn't try to mimic his conduct. She fell back. She hung back as she testified. She waited for the police helicopter to engage. After he left the highway and went down the median, she thought he spun out. She was going, under this record, between 4 and 28 miles an hour. He had gone through the intersection. She thought he had had an accident. She noticed dust flying up. She had stopped and started to proceed forward to see if anybody had been injured in what she believed to be was an accident. That's when the suspect, Mr. Rodriguez, did a 180, drove the wrong way on the frontage road, and charged her. Officer Corey testified, and the Court of Appeals didn't disagree with this, that she was going about 4 miles per hour because what happened was he charged her. She thought he was going to hit her. She pulled over to the right and braced for impact. She had come to a complete stop. When he went by her, she said, missing him by inches, she started to turn her vehicle around, and that's when she heard the collision. He had hit the Masperos' vehicle head on and killed 2 of the Maspero children.
If Officer Corey had used her siren, would that have warned the Masperos and potentially allowed them to take evasive action?
I don't believe so, Justice Bland, and this is why. There is not an allegation here that anything related to the siren or its non-use caused or contributed to cause to this incident. She had her flashers on. The transportation code says that the use of her siren was discretionary. There's no testimony in the record from anybody that if she had had the siren on when she exited or came to a stop. The Masperos were coming off the freeway, by the way. They were exiting, and then they hit Mr. Rodriguez head on. They were not close to Officer Corey. She was much farther ahead of them. So there's no evidence in this record that the siren would have made a difference at all. I also think under this court's opinion in Cassin that really triggers on whether the non-use of the siren can trigger waiver of immunity, and I don't believe that it can under this court's opinion.
Would you say that a siren is integral to the operation and use of an emergency vehicle?
I don't think it's integral as the emergency brake was in this court's opinion in PHI, where it said the failure to engage an emergency brake is so integral to the vehicle that it allows it to roll back. That constitutes operation or use. I think the siren is more like the warning case that the court issued, that the failure to have a warning is not operation or use in this case.
Are you arguing official immunity? Have you argued official immunity as a separate basis for?
We have argued official immunity, and that goes to the recklessness that I'm also going to address, Your Honor. The one of the halves of the Pursuit Plus is that even if the court finds that the operation or use of the vehicle was the actual cause of the injury, then they have to show that Officer Corey, at the time of the incident, was acting recklessly. And that goes back to 2 things that I was talking about. All of the focus of the Court of Appeals' opinion on her conduct was when she was on the freeway. They said she drove up to almost 100 miles an hour. All of that conduct didn't happen, it wasn't related to the injury or the accident. At the time of the accident, she was stationary. Nobody has argued that at the time of the accident, she was misusing or improperly using her vehicle. She exited the freeway. and instantly was driving less than 50 miles an hour, which was the speed limit on the frontage road. The brief of the merits of the respondent on pages 10 and 17 acknowledged that she wasn't speeding at the time of the accident, and she had come to a complete stop. So she wasn't behaving in a reckless manner. The standard for recklessness, as the court knows, is she would have to have known about the danger and acted as if she didn't care. Or as this court said, in the Bonner opinion, they would have to show, this record would have to show that she had the quasi-intent to harm. And there's just no evidence of that on this record. In that regard,
But doesn't that argument really hinge on there being two different incidences in a sense? The incident of her chasing, and then once the car goes down the embankment and the police officer then follows that car, not down the embankment but down an exit, and then thinks that there's a crash, and goes down there, and then the car turns around and comes this way. For your argument to stand, wouldn't that all have to be seen as two different things?
I understand your question, Justice Lehrmann. I think this is the distinction that I would draw. The court's analysis in Ryder talks about whether it's geographically, temporally, or causally to attenuate it. And I think that your focus is right. What was happening if she had had an accident when she was going up to 100 miles an hour on the freeway, and she had been driving erratically at that time? Under this court's jurisprudence, I understand there could be an argument that the incident arose from the operation or use of her vehicle during the pursuit. But once she exited the freeway and he decided to not flee her, but to do a 180-degree turn and charge her, I don't think it's a fair assessment of the record to say that the pursuit was still occurring. He charged her. The cause of this accident, it's like the city of Baytown versus Williams, Justice Bland, that I think you wrote. Justice Huddle, I think you were on the panel, was that the police, in that case, use of a box-in maneuver to keep somebody from escaping. And the court held that the cause of the accident wasn't the box-in maneuver. It was the fleeing suspect's decision to try to crash the box-in maneuver and continue to flee. That's what happened in this case. Mr. Rodriguez didn't continue to flee. There was not a contiguous fleeing incident. He decided when he spun out, rather than flee, to do a 180 and to charge Officer Corey. Nothing about the way she was operating her vehicle or not using her siren contributed to cause an accident that was caused solely by his decision to turn around and charge her vehicle and have a collision with the Masperos vehicle behind them.
What if his decision to turn around was not really to charge her vehicle, but was to get away from her? Because if you're going the opposite direction in a one-way, roadway, the likelihood of other vehicles following you is less.
I think it would still require her to be doing something with her vehicle that was negligent at the time. For example, if he decided to flee her, he hadn't hit the Masperos, and she had turned around and reinstituted the chase. If she had been driving with him the wrong way on the frontage road and driving up to 100 miles an hour, I would agree with you that the pursuit would have been contiguous and it would have mattered. But there was nothing, there's no argument that at the time of the incident that she was doing anything wrong with her vehicle. She had pulled over. If the law is going to be, in the Scott case from the U.S. Supreme Court says this, it's cited in our brief of the merits, that it will create a perverse incentive if somebody starts driving 90 miles an hour and immunity is waived every time a police officer decides to engage in a high-speed chase. And I want to briefly, have a couple of minutes, I want to briefly go back, Justice Blacklock, to your question about recklessness. Because...
So, and just to, on my question, I saw where you argued recklessness in the context of the emergency exception, but I'm not sure I saw official immunity argued separately.
No, the only immunity argued we have the waiver argument and then the emergency exception argument. I'm sorry, I misunderstood you. If you said, did we also argue ordinary official immunity? We did not.
Okay.
The brief addresses the emergency exception, and I want to address that for the court. The Court of Appeals here, under this court's opinion in Texas Department of Public Safety versus Vanilla, was required to consider all of the evidence to determine whether Officer Corey was acting in good faith at the time. The Court of Appeals focused on her speed on the freeway, whether she had express authority, whether she had activated her siren, and whether, in hindsight, the benefit of apprehending the suspect outweighed the risk to the public. What the Court of Appeals ignored was she engaged her emergency lights. She stopped at signs or intersections when Rodriguez ran through them. She hung back. She knew she couldn't catch Rodriguez. She tried to keep him in her sight. She said she reduced her speed to minimize the risk to the public and to wait for the helicopter to engage the pursuit. She wasn't speeding at the time of the collision, and that while she was doing this, she weighed the risk benefits of allowing a suspect believed to have a large quantity of drugs, 420 pounds, who had not been positively identified, to escape and destroy the drugs or release them into the community. The Court of Appeals reached an opinion regarding recklessness even the plaintiff's own expert could not reach. Their expert, Police Officer Blacklock, at 433 in the record, opined that she violated a reasonable standard of care. He also said at 429 in his affidavit that he was familiar with the term restless disregard and conscious indifference. He did not say that she acted with reckless disregard or conscious indifference. Her affidavit establishes the elements for good faith. His is conclusory and doesn't challenge it on key components. So the Court of Appeals reached a conclusion that her own expert could not reach. I see I'm out of time.
Any other questions? Thank you, counsel.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Courtney will present argument for the respondents.
May it please the court. I think the first thing to address is the issue of the siren, because that seems to be where a lot of the argument is focused at this point in time. It is incorrect to say that the use of the siren was discretionary. Under the Texas Transportation Code, Section 547.702 requires in a police chase the use of a siren. That siren's purpose under the statute is to warn other individuals of the existence of the dangerous chase. That section has never been addressed by the petitioners in this matter. They address Section 546.004, which provides for some exceptions to the use of the sirens for those instances which are covered by 546.001. Those are not implicated in this case. In this case, we have a two-way access road, feeder road, frontage road. We know from the facts of the accident that Officer Corey's patrol car is in the immediate vicinity of the impact. Why? Because Officer Corey says, he came right at me, he missed me, and then bang.
But
right?
what is your response to the argument that that is non-use?
So, a patrol car has a siren for a reason, just like cars have an emergency brake for a reason.
Well, but in a lot of our cases where there's non-use, the thing that wasn't used always has a good reason.
Well, there was a reason to use the siren because the statute says the policy of the city of San Antonio under 609, the policy document that's in the record, also requires that if there is a police chase, that the officer use the siren. The only exception to that is if they get authorization, verbal authorization on the record. We have testimony from Sergeant Scarmosi that that authorization was never requested and certainly was not given. So we have an immediate impact. We have the Maspero vehicle that is exiting the expressway. We have a car that is stopped at the yield sign facing the opposite direction. We have Officer Corey that is obscured by the car that is at the yield sign. The fact that she's rolling her beacon lines or lights does not warn the Masperos as to what is going on. Their view is obstructed by the car that is sitting at the yield sign. When David Rodriguez pulls around and impacts, the only thing that was going to warn the Masperos was Officer Corey's proper use of her integrated siren. And that is certainly, I don't know how many times Judge Moore has instructed juries as to there may be more than one proximate cause. Certainly the non-use of the siren in this case by the patrol officer is sufficient to show that proximate cause. And the nexus analysis that this court compels us to go through is supposed to be like that proximate
And is
cause.
that what you're resting your argument on? Or let's say if the court were to say that that's not going to be an appropriate waiver, the non-use, then what's your argument?
Well, I agree with Judge Moore when he began his statement that this is, it's got to be a pursuit plus. In this case, we have lots of elements. First of all, we have the clear violation of the statute, right? We have a statute that requires the use of the siren, and the siren's not on. Second, in terms of recklessness, we have lots of evidence that this was a reckless police chase. It wasn't approved, which is one of the requirements in the city of San Antonio, under the same standard that we have talked about, Standard 609, which is in the court's record. The pursuit itself, on and off the expressway, again, without the siren, at high speed, at 5 o'clock in the afternoon, through school zones, is clearly reckless. The operation itself was supposed to have a helicopter that was available. The helicopter's not available. One of the planning documents says the operation is no-go if the helicopter's not available.
What about the argument that this was basically, a separate incident? Because once the car went down the embankment and then the police car exited, then at that point in time, the police car wasn't doing anything.
I know
inappropriate.
petitioner's brief complains about how much focus we put on the facts of this case, but one of the things that the facts reveal, because this was somewhat unique insofar as that there is a geolocation device affixed to the patrol car, right? We know the speed of the patrol car, but we also know the direction that it's pointing. And so in the brief, we talk about how the azimuth of the patrol car is changing, right? The reason why Officer Corey has pulled to the side of the road on a bidirectional two-lane access road, why she has pulled aside is because she's attempting to turn around. She knows that Rodriguez is now moving this way. She's facing this way. She pulls to the side, and her azimuth is changing at the time of the accident. This police pursuit has not stopped. She's trying to turn around. And the only way to do that in a two-lane road is to pull wide to the right and begin turning your car. And that's what she's doing. This is not a situation where she has somehow decided, well, the chase is over because he's facing the wrong direction. She sees the car coming at him. She's not running her siren, is what she's supposed to be doing, and she's attempting to continue the chase.
Is the siren intended to warn of the approaching emergency vehicle? And are you suggesting that the duty extends to using the siren to warn others of the criminal conduct of a third party?
Well, I think it's to warn others of the fact that this is a situation which is going on, right? The fact that you're warning, the siren's not helping the officer. The siren's not helping the bad guy.
But is it to stay clear of the emergency vehicle as opposed to extending to other surrounding cars?
I think the siren is like the horn on a car. It doesn't necessarily tell you what the situation is, but it requires you as another driver, or it should indicate to you as another driver, there's something going on.
And does the failure to engage it constitute recklessness, and why?
I believe it does because it is required by statute, it's required by policy, and there is no explanation as to why she didn't engage the siren. It wasn't that she was sneaking up on someone. It wasn't that she was concerned about whether or not they were going to, dump evidence. She's not running their siren for something that's completely inexplicable.
The question of recklessness,
I'm sorry, Judge.
the question of recklessness and the question of nexus, are those fact questions standing alone, or are those legal determinations when the underlying facts are undisputed?
Well, the question of nexus is supposed to be like that of proximate cause, right? And this court has indicated in numerous cases that proximate cause is usually a question for a jury. The only time that it is not is when the alleged negligence, for lack of better terms, is too attenuated or remote. But here we have Officer Corey right at the scene of the accident.
So the question of whether the wrongful act is too attenuated or remote is a question of law for the court to decide if the facts are undisputed?
So it's a question of law, but it's still decided on like a summary judgment standard. So if I present evidence that it's not too attenuated or remote, which I think I do. The city of San Antonio had its own police report of this accident. If you look at factor number 1, they say police chase. They didn't think that the police chase was too attenuated
Right,
or
but what
remote.
I'm getting at, let's go to recklessness to make this a little simpler. We can apply this to the nexus question too, but does the evidence in this record include conflicting evidence that creates a genuine issue of what happened, fact,
Well,
from
certainly.
which that is relevant or material to the recklessness question? Or is this one of those cases where it's just a dispute over whether the undisputed facts meet the standard of recklessness?
So specifically in regard to the siren, Officer Corey indicates that the siren was on. However,
So there's a fact issue in this record as to whether the siren was on, but and it's a fact issue because you've tendered evidence that it was not.
Correct.
And it's your view that evidence that the siren was not on is some evidence of recklessness that would avoid jurisdictional dismissal here.
Correct.
And I guess what I'm getting at is, isn't it a question of law for us to decide whether, let's assume you're right, take all facts in the light most favorable, the siren was off. Is it your argument that it now becomes a fact issue as to whether the absence of the siren was recklessness, or is that a legal issue for us to decide? Let's assume they don't dispute that the siren was on. Let's assume that no facts are in dispute here. Everybody stipulates as to exactly what happened is the way you've described in your briefing. This is what happened.
I think
Can you
ordinarily,
just come in and say, and that creates a fact issue as to whether this conduct was reckless that a jury has to decide, or can we decide that as a question of law in the absence of any disputed facts?
I think you can decide it as a question of law insofar as the statute requires the use of the siren. So that becomes, I think ordinarily the existence of negligence is a mixed question of fact and law. But in this case, you have a statute that's right on point that requires the use of the siren for the purpose of warning other individuals. So in this, in terms of the evidence that the siren was not used, the City of San Antonio's report, which is at CR 301, Sergeant Scarmozzi's testimony at CR 403, two other officers of the City of San Antonio testified that they didn't believe that the siren was on. That's at CR 385 and CR 423. And a disinterested witness also who testified that he didn't believe the siren was on was at CR 423. Again, you have a situation where the fact that there were beacon lights running doesn't provide any warning to the Masperos because of the juxtaposition of the car waiting at the yield sign.
On the question of proximate cause, why wouldn't we look at the fleeing driver's decision to go the wrong way on the ramp as sort of a superseding or intervening cause that, I mean, sure, she engaged in a high-speed chase, but she didn't chase him up the ramp, and he made that decision to do that, extraordinarily criminal and reckless act, outside of anything that she caused him to do.
I think it's important to remember that the fleeing driver is not going up the ramp, right? This is a bidirectional access road with one lane, the lane closest to the highway, running the opposite direction of I-35. So the lane closest to the highway on this access road is headed north. The I-35, they were headed south. So Rodriguez he's not going against the lane of traffic. What he is doing is he has pulled over to pass the car that is waiting at the yield sign. Okay, so he has gone into the oncoming lane. Again, Scarmozzi's patrol car is here. We have a stopped car here. He is whipping around the stopped car to proceed on the side, and she's turning back. Does that make a little better sense? So he's not actually going up the exit ramp. The Masperos are coming down the exit ramp. There's a stopped vehicle that's yielding to them. They don't have any reason to assume, based on their perspective, that there's some reason that they should be extraordinarily careful or stop or slow down or anything else. And the impact.
So your view of what he's doing is he's going to get back on the. He's not going to go up into the highway. He's going to get back on the feeder road after he swerves around the car in front of him.
Yeah, Justice Lehrmann obviously has watched as many westerns as I have, and you always double back, right, to escape the posse. Get them going one direction, you double back. So I think that's exactly what he's doing. He's doubling back.
But you do not disagree that he was committing a felony in the course of his conduct, escaping the police officer?
Just it depends on what fiction we want to adopt in this case, right? Because this was a pretextual stop, right? We're going to stop him because we're going to say that he didn't use a blinker, right? Because we don't have any real evidence that he's actually carrying narcotics. We have a suspicion, right? But none of that is confirmed until after the accident, right? So all we know is he has been at a location where an informant has said that they are distributing narcotics, and he is now leaving that location. We're going to stop him on a pretextual stop. So at the time, you don't have any sense that there is a felony other than the broad supposition, we think we know how this operation
But
runs.
fleeing, and in the course of fleeing, causing injury, regardless of
certainly-
whether he was guilty of an underlying felony.
There's no question that at the moment he impacts the Maspero vehicle, he is engaged in a felony. Yeah, that's fleeing and causing injury. That's no question. Up to that point in time, I think there's probably a lot of question as to whether or not the traffic laws that he had violated in, speeding and everything else that was going on, did those rise to a level of a felony? Probably not. So, look, it's the respondent's position that this case is relatively simple under the court's analysis that's been presented in Ryder. This is not the Fourth Court reaching out beyond that. I think it's the Fourth Court acknowledging the fact that in this case, there is evidence to support we don't even have to get to the reckless standard, right? We know that there was a violation of a statute by not turning on the sirens. But if we get to recklessness for the issue of the emergency use exception, we still know that this was a reckless operation because the officer is not complying with those rules that are promulgated by the City of San Antonio's Police Department for the conduct of these chases, right? She doesn't have authorization. The authorization must be on the record. It must be verbal. It must be recorded. The idea that there's some sort of super secret implied authorization is just contrary to what 609 requires. 609, for the court's convenience, is at CR 389 to 400, with the requirements of the siren being demonstrated in that.
Any other questions? Thank you, Mr. Courtney.
Thank you, Your Honor.
Mr. Moore, you have 5 minutes.
All right. I want to start.
Is there some tension with the outcome you're asking us to adopt and Ryder? Because the way that you're suggesting we look at this is sort of to not focus on the facts of the chase itself and look at the precise moment when the accident happened. And in both cases, what you have is neither police car involved in the accident, just sort of off to the side. Is there some tension there?
I don't think so, Justice Huddle, and this is why. In the Ryder opinion, the court noted that the operation or use, the cruiser was in operation. He had pulled over to the right. He had done a 180, and he was flashing his headlight spotlight into oncoming traffic. And so in that case, the court said, and it was a pleadings case, not an evidence case, it was just whether they had pleaded a causal nexus, that was enough of a causal nexus because it was foreseeable that if you night blind oncoming traffic, then an accident can result from the operation or use of that vehicle. I don't think there's tension here because at the time of the collision, the operation or use of the vehicle, Officer Corey wasn't doing anything improper with her vehicle. And I think that's the distinction that resolves the tension. I want to hop around a little bit, but one thing I want to address is this notion, and I can actually hear again, is this notion that she did not have express authority. The record supports that the officers testified that she had implicit authority, and they're taking the position that she didn't have the authority is directly contrary to their position that her act was non-discretionary because she was ordered to pursue and stop him. It can't be both. She can't both require express authorization and be doing something mandatory, and that's the position they've taken in their briefing.
Is there a reason that the city didn't argue official immunity as a separate ground the way it did in the next case we have today?
I think the difference is this was initiated as an emergency response, a high-speed pursuit, and so the factors that I'm going to talk about in Maspero on particularized risk and need are different for immunity in that case than this case. And in this case, the standard is a little different under Chambers and Wadewitz, that she would have to show that she assessed the benefit risk and made a determination to act in good faith for the emergency exception. And I think that her exception in this case was triggered by the pursuit and the emergency nature of it that doesn't exist in Maspero.
Get around all this business about a violation of law or the policy, if potentially with official immunity.
I want to take issue with something that's come up in that regard. A violation of policy isn't enough to waive immunity under Varela, and a violation of a statute isn't enough to waive immunity under Varela. It has to be under 546, which succeeded 6701, where it used to be due regard. It now has to be reckless. So unless there's some evidence in the record that she recklessly violated a mandatory policy or she recklessly violated a statute with quasi-intent to harm, it's just not enough.
And that's, to be clear, that's assuming the emergency exception applies to begin with.
That's correct, Your Honor, and I don't think there's a dispute in this case about whether it applies.
Which
I
is
think
the
that's
difference
undisputed.
you were describing in the next case. But,
Right.
but if an emergency existed, it's because there was a police pursuit going on. And yet you've tried to distinguish the police pursuit as a separate incident from the accident happened once the officer had quit pursuing and pulled over. You've argued that we have to judge her conduct and make the determinations based on that moment when the impact occurred and she had pulled over, regardless of what had happened before. But doesn't that same distinction take away any emergency? Now, why is the emergency still going if she's quit pursuing and they've pulled over?
I think her attempt to arrest and follow him, even if she's not trying to catch him, she's still in an emergency situation. She's initiated a stop. He has fled. I think where I diverge with that question is I'm focusing more on the causal nexus. Once the emergency exception is triggered, then that section applies with regard to immunity. But for the first prong, for the plaintiffs to get past the waiver, they have to demonstrate the causal nexus exists under this court's opinion in Ryder. And I've talked about how that's different than this case. So I don't think I'm asking the court to take two separate positions. I'm saying causation is inherent in both analyses. It's inherent in the waiver of the immunity, and it has to be reckless in the good faith in the emergency exception. But I don't think I'm asking the court to bifurcate the two.
Any other questions? Thank you, Mr. Moore. The case is submitted and the court will take a brief recess.
All rise.